In recent years, the movement for LGBTQ rights has gained unprecedented momentum. Those of sexual minorities share more rights with respective majorities than ever before. They are far more willing to express pride in their choices. Private interests voice their support for the LGBTQ community in campaigns which, although admittedly cheap, are indicative of societal change meant to guarantee their creator-endowed rights of life, liberty, and the pursuit of happiness to this population. Yet, it would appear that the leaders of this movement are directing all of this clout into the wrong pursuits. It is no secret that homophobic worldviews continue to foster discrimination, most prominently in the workplace and in the housing market. The prevailing train of thought within the LGBTQ movement is that the best way to combat such discrimination is to push state legislation banning such practices. However, federal laws are already in place to deter them. The Civil Rights Act of 1964 bans employment discrimination on the basis of ethnicity, national origin, religion, or sex, and the Fair Housing Act, passed in 1968, bans housing discrimination against said classes. Furthermore, in the 1989 case Price Waterhouse v. Hopkins, the Supreme Court ruled that discrimination on the basis of defiance of gender roles or stereotypes, such as male expectations of dress, speech, and gait as compared to those of females, qualifies as sex discrimination. Some would inquire how these statutes forbid discrimination against homosexuals, transgenders, and the like. After all, there is no explicit mention of them. Well, the key is in the Supreme Court ruling, in its expansion of the term sex to refer to gender roles. In the case's original context, this expansion equated discrimination against transgenders for following the gender expectations of their gender identity with sex discrimination. Notwithstanding, this interpretation of the aforementioned legislation also has implications for the equality of homosexuals. Generally speaking, men in our society are expected to have sex with women, and women are expected to have sex with men. The expectation of a person's sexual orientation differs based on their gender. Therefore, society holds men and women to different expectations when it comes to their sex life, and, according to Price Waterhouse v. Hopkins, employers, renters, leasers, etc. cannot deny employment or housing to a given party solely because of the latter's defiance of those expectations. In sum, the issue at hand is not that the United States lacks legislation to combat LGBTQ discrimination, but rather that the legislation has not been used to do so. The legislative branch of the government, that is, Congress and the state legislatures, have already done their job in giving citizens the tools to fight such discrimination. It is now up to the courts to recognize these tools can be used to guarantee equal opportunity to the LGBTQ population of the United States. Indeed, more and more authorities in the judicial branch appear to agree. The Equal Employment Opportunity Commission concluded that discrimination against transgenders and homosexuals qualifies as discrimination in 2012 and 2015, respectively. And was it not the Supreme Court who struck down laws that prevented the recognition of gay marriage? In light of all these developments, comprising 55 years to hold the United States to its promises, it is my firm view that LGBTQ discrimination is already illegal. My name is Monty. Make me your 45th and a half president on November 4th, 2019.